Good morning, friends. This is Dr.S.Elumalai. Welcomes you on behalf of Legal Breeze, a channel which gives you a complete update on the legal educational side and related aspects. In today's program, we will be discussing about the rights of minorities guaranteed under the Constitution of India. People may believe that only Article 29 and 30 speaks about or enumerates or protects the rights of people or citizens who are belonging to the sections of minority in the Indian society is concerned. But to me, it is true to a certain extent, but the constitution goes beyond it. It is covered elsewhere also, other than under Article 29 and 30. However, due to the scarcity of time, we may not be in a position to go through all of them in depth today, but that can be covered in a separate lecture at an appropriate point of time. For the time being today, we will be discussing in this edition what is the concept of minority, who can be qualified to be called as minority, what is the criteria to identify a particular section of citizens of the society is belonging under the category of minority or not, what are the rights guaranteed to them, and how the rights have to be exercised. Is there any conditions or is it absolute? All these aspects can be dealt under this program is concerned. First, let us talk about who can be the minorities. There are two answers possible under the Constitution of India. If you read Article 30 carefully, it spells out only two categories of minorities specifically. One, linguistic minority. Two, religious minorities. However, the rights of religious minorities trumps over the rights of linguistic minorities in today's vote bank politics. It's a sad story. However, due to the scarcity of time, which may not be possible for us to go through all those things in this video is concerned, when time permits, certainly we will address these aspects at a later point of time. But if you go by Article 29, it's a very wider one. In fact, the title of 29 says protection of the interests of the minorities, and it lays down certain criteria to identify a particular person belongs to a section of minority or not. What it says, first, a section of citizen of Indian society, if it has a distinct language or distinct script or distinct culture, it can be read disjunctively or conjunctively depending upon the circumstances. Then, if they have a distinct language, script, culture, then they have the right to conserve the same. This is very important. This is a right guaranteed to all sections of society. Under Article 29, there is nothing called religious. It is very secular in nature. For example, there are certain sections who called visually challenged under the persons with differently able category. The present government addresses them as Divyangjan. The visually challenged people are having a script called Braille. This is a separate script. Naturally, when you have a separate script or separate language, then it may lead to have a separate culture. This is connected with one another. Please, we should remember these things. So, can they be considered as minorities under this article, under 29? If not for the purpose of Article 30, the answer should be yes. But we need to have an authoritative interpretation from the Supreme Court of India that will settle all this issue. Secondly, the language includes sign language, Braille, all these things have been spelled out through a convention called Convention on the Rights of the Persons with a Disability, to which India happens to be a signatory And India is one among the country which has one among the few countries which has signed as well as ratified this aforestated convention. That convention says language includes braille and sign language. So the people who are hearing impaired can also be considered, can also be treated as minorities if we go by the true letter and spirit of Article 29. Then the cultural rights, they need not to have language or script, but if they have a separate culture, for example, the latest issue, thanks to Justice Chandrachud ji, his interpretation on the rights of transgender LGBT, I humbly believe that they are also entitled to preserve their own culture under Article 29. Article 30 is only a tool to facilitate the conservation of their cultural rights, educational rights, and other rights analogous to that. How? By establishing and managing the educational institution of their own choice. This can be spelled out or demonstrated even for the visually challenged and hearing impaired also. Say example, a person who belongs to visually challenged can be imparted through braille language, through a separate schooling system. Throughout the world, this is being permitted. But whether they are given the minority status in our Indian Constitution, I think the days have not come to such an equivalent. But please remember, our Supreme Court is very much vibrant and resilient in giving wider interpretation and injecting new blood into the Constitution. In a case called Odisha Mining Corporation versus Union of India and others, this is popularly known as Vedanta Steel Factory case. The Supreme Court has categorically mentioned that the rights guaranteed relating to the religious faith of the tribes under the Forest Rights Act, it can be equated under the freedom of religion guaranteed under Article 25 to 28. In fact, the letter and spirit of the judgment shows that it goes beyond that. That is the spirit of the judgment. I hope when the occasion comes up before the Supreme Court, such a pronouncement may be feasible, not only for this differently abled and for the transgenders also in the future. Then the right to administer educational institution, right to establish an administration of educational institution or management of educational institution, is it regulated under the Constitution, or what is the purpose of guaranteeing such a right? The answer can be found by mere plain reading of Article 29. In order to achieve the objectives enshrined under Article 29, Article 30 is a tool to achieve the objectives of 29. Now, whether it can be curtailed in the name of regulation by the government, both by the center and the state, the answer is no. It has been inserted by an amendment, namely by the 44th Amendment of the Constitution of India, in the name of acquiring properties, compulsory acquisition of the properties. These rights cannot be curtailed or abrogated in the name of acquiring compulsory acquisition of the properties belonging to the minority educational institution. In my humble opinion, it shall be extended to the categories whom I have mentioned. The same has to be given to the tribes also. This is very important. By reading of the Forest Rights Act and other analogous judgment relating to the aforestated affairs is concerned. The linguistic issues, linguistic minorities have to be guaranteed. It should be more effective. Particularly, it assumes more importance after the reorganization of the states on the language basis, linguistic basis. So again, religious minority as well as linguistic minority, how it can be constituted? Say example, if I go to Goa, a Hindu goes to Goa or Kashmir, they can be minority. So whether they are entitled minority protection in those states, To the best of my humble wisdom, the answer is no, as on date. We all go by the vote banking policy. That has to be curtailed. That is the reason they have given all these safeguards. All these safeguards. There are certain states which provides communal reservation based on religion, not on language. Why? Because for them it attracts the vote bank. The concept which we have fought against the British, dividing the nation on the communal basis or religious basis, now it is indirectly done in the name of protecting the interest of the minorities, only for the religious minorities. States like Tamil Nadu, Andhra Pradesh have given reservations to the Muslims under this category. Though many a time the Supreme Court has struck down, at least in the case of Andhra Pradesh. I am not sure whether it has been done in the state of Tamil Nadu, because it continues. All Muslims are being treated as basic Muslims. What is the criteria to treat them? We do not know all these things. Of course, we will not go into all those things for the time being. So religious minorities' rights have been more guaranteed, and more cases have also come before the Supreme Court. Thereby you have good number of literature. You have 11 judge bench case decided by the Honorable Supreme Court of India and TMF Pai Foundation. You have Islamic Academia case. Then you have the P. Inamdar versus State of Maharashtra. All of them are pointing out the minority rights. Right to administer educational institution and manage the same. Whether it can be linked with the under Article 19(1)(g, the answer is yes. But is it a trade right or business rights? The Supreme Court says no, it's only a profession. It cannot be for profiteering. That's the answer. And implications of globalization, that we need to analyze. Tomorrow a foreigner comes, necessarily he can be a linguistic minority or religious minority. Whether his or her institution, foreign institution, can claim the benefit under Article 29 and 30, the answer is no, because it has been confined only to the citizens of this country. So, but if you have signed, I am sure there are many treaties which we have signed under under WTO. Whatever rights you are granting to your own citizens ought to be granted to the other nationals, foreign nationals. So we need to evolve a right sort of balance in the aftermath of globalization. Article 15, Clause 5 and 6 again has to be given certain sufficient light on this issue. Now, how this Article 15, Clause 5 and 6 has come, you all know. This is because of a reading given by the Honorable Supreme Court. In P. Inamdar versus State of Maharashtra, they said all professional educational institution, higher educational institution, has a duty under the Constitution of India, fundamental duty to promote excellence of this country in a particular field, particularly education, science, etc. Therefore, they said all of them should provide reservation to citizens of this country, the private educational institution particularly. However, when the same has been translated into the constitutional amendment, the politicians have chosen to exempt only the minority institutions, particularly unaided minority institutions, whereas non-minority unaided private institutions have an obligation to fulfill the reservation under Article 15, Clause 5 as well as 15, Clause 6. It's a very sordid state of affairs, because the right to education is the only one which encompasses all three stages. Like it is a DPSP, it is a fundamental right, as well as it is a fundamental duty as laid down under the Constitution of India is concerned. And there can be distinct fundamental rights for distinct categories of citizens, including minorities, but there cannot be a distinct fundamental duties depending upon the status of your citizenship or depending upon the status of your minority or non-minority status is concerned. At the same time, we need to ensure that the majoritarian tyrannism shall never take over or shall never give room for abuse of minority rights. That is the reason the constitutional framers have given such a greater safeguards. In today's politics scenario, Secularism means appeasement of minorities is treated as secularism. And when you bring reforms in Hindu religion alone, it is being treated as secularism, whereas there is no political will to bring reforms, which is part and parcel of under Article 25. As they say, it is a violation of secularism. If you speak about uniform civil code, even uniform criminal law is being attempted as violation of secularism. The best case is Shabano case. We hope good sense will prevail over and the good constitutional spirit will be reinforced in the globalized era. Thank you all. God bless you.